Hi, I'm Charles and I'm your host today for the amazing world of administrative law. So today we are talking about public interest immunity. Public interest immunity is an exclusionary rule that allows the public bodies to retain relevant and tangible evidence that are being requested by the citizen as an evidence in legal proceeding. So there is a concern of public interest immunity rule causing injustice in legal proceeding as the refusal of disclosing could jeopardize the case brought by claimant. The justification of public interest immunity is on the balance between the public interest and the necessity of providing information as evidence in the court, where in certain circumstances the court thinks the retaining of the information has more merits than the public interest in the due administration of justice. Therefore, occasionally, the public bodies are able to avoid judicial review where they raise the argument of public interest immunity. If the government have the public interest immunity certificate, they will not be required to disclose the information as evidence in trial, as it would be a favour to the public interest if the information is being kept as a secret. This can be illustrated in the case of Duncan and Camilla, where the facts stated that the relatives of the deceased were claiming for damages because their partners died in the submarine designed by the defendant. The defendant refused to disclose the design as it was against the public interest. Therefore, the House of Lords held that it could not be questioned in court as it was the matter related to national security and therefore fell into the category of documents which should not be disclosed.
Where are they? Did they die?
Yes, they died.
Why did they die?
All I can say is PII. This has given the government the ability to disclose or withhold information by choice, which can be exploited by the government, especially when the function of executive has also been extended towards different areas because of the industrialization of the country, which currently they have provided regulation to various social services, for example, housing, education, transport, and more. Therefore, it's very likely that a decision made by the executive could possibly affect the citizen, and in some circumstances, executive may exceed their power and infringe the right of the citizen. Therefore, throughout the years, it is very important to monitor the environment of public interest immunity, as it will be important to see whether it has caused the concern of the public as it might lead to an abuse of the state power. So here are my guests and each of them are going to talk about an issue. Start with Ethan.
Yeah, we'll be talking about the justification of why there's a need for PII.
I'm Alanis and I'll be talking about the involvement of the public interest immunity over the years.
I'm Lord Justice Gideon, and I will be presenting about the concerns of public interest immunity.
So enjoy our presentation.
Public interest immunity, which superseded from the Crown privilege, derived from the same principle as the immunity of the Crown from prosecution before the Crown Proceedings Act 1947. However, as the name now implies, it is not only for the Crown, but rather everyone who makes up the public. Back in 1942, in the case of Duncan and Camel Day, ministers certified that disclosure of information on matters regarding national security was against public interest. Thus, no disclosure of information was allowed. The House of Lords also held that the minister had the final say in this matters, and it may not be questioned. Later, in a more recent case, which is the case of Conway and Brewer in 1968, the House of Lords established that the courts, not the Crown, had the final say in whether a claim of PII succeeded, thus reversing its own decision in Duncan and Camel Day. To add up to that, House of Lords decided that there were no blanket immunity for any class of documents. However, not all not all of the documents fall under a certain category where prima facie must be disclosed. The case of D and NSPCC, however, represented a departure from this rule as NSPCC informers were granted the same protection as informants to the police and the gaming authorities. The journal article should vulnerable people who provide information on alleged abuse be entitled to public interest immunity stated that the case had established the rule where public interest immunity applied to information provided to a cause where there is a broad public interest like child protection agencies. Those referrals could be made in confidence. This carries the public interest in encouraging the public to come forward to aid the authorities to protect children. In this case, this treatment of her daughter came to the knowledge of the NSPCC, which is the National Society for the Prevention of Cruelty to Children, which resulted in an inspection of her home. These sued for the disclosure of information and seek for damages for nervous shock. The NSPCC claimed public interest immunity against the discovery of documents which might reveal the identity of their informant.
What are you doing?
Oh.
Oh no, get out. Lord Edmund Davis, in the case of Burma Hall, was reluctant about adopting Rich Algae's principle for future Class C claims due to it being able to encompass far too wide theoretically, as well as it is by definition not confined to claims by or related to the central government. Williams, in the journal article Crown Privilege and Burma Hall, had said that the decision of this case has also pressured the House of Lords to reconsider its decisions in the previously decided cases like Science Research Council and NASI 1979 to disassociate prerogative with Crown privilege in order to achieve a more impartial immunity based on the public interest. Furthermore, Lord Scarman, in the decision of Science Research Council and NASI 1979, expressed his resentment of the passing of the term Crown privilege as it implies that the area covered by the public immunity is restricted only to a certain group of people. It was established in Act Canada and Secretary of State for Trade in 1983 that public interest immunity is a matter of discharging a duty rather than claiming a privilege, where in this case, there was an increase of landing charges in Heathrow Airport, and the plaintiff said the increase was more than necessary. They argued the implementation of that government policy was ultra-wiry. They then requested for the disclosure of related documents that leads to the implementation of that policy. House of Lords held that by a majority the government was entitled to immunity. The party seeking disclosure of the documents must be able to prove that the documents are likely to contain material which supports this contention which arises in the case.
Okay, cut. No, it's not enough.
What? 20?
No, it's not.
Continuing with the concern in relation to the extent to which government may be required to disclose information to the court of law, it is clearly a need for public interest immunity. In relation to this, the original case of Duncan and Kamel shows that sometimes it is important to have such law of public interest immunity, as it is not only protecting the public, but at times it protects the national security. This further leads to the conclusion of the House of Lords have made that certificate of public interest immunity cannot be questioned and ought to be final. The extent which the government may be required to disclose information to the court of law should be ultimately decided by the executive and scrutinized by the court. As seen in the case above, the claimant sought to claim the damages for their deceased family members. They brought a claim under the builder of the submarine, which it was during the time of war. It is therefore said that by proceeding into the claim, useful and confidential information may be leaked, and this will place the UK in a disadvantaged position. After this case, there was disputes on whether which topic to be disclosed and which should not be disclosed. Under the Law of Criminal Procedure and Investigation Act 1996, Section 23, Sub 1, Code of Practice, Section 6.15 states that disclosure must list on a sensitive schedule any material and disclosure of which he believes will give rise to a real risk of serious prejudice to an important public interest. And the reason for that belief is that the schedule must include the statement that the disclosure officer believes the material is sensitive depending on the circumstances. And this example can be categorized into this field of material relating to national security. Example can be seen in the Duncan's case. Journalist sources under the Section 10 of Contempt of Courts Act 1981, which simply states that no court shall require anyone to disclose a source of information unless necessary in interest of justice, national security, and the prevention of disorder or crime. Next would be the prevention and detection of investigation of crime, and lastly would be the material relating to children. Also in the later section of Section 6.16 states that in exceptional circumstances, when investigator considered the material is so sensitive that it is revelation to the prosecutor by means of an entry on the sensitive schedule is inappropriate, the existence of material must be revealed to the prosecutor separately. This will apply only where compromising material would be likely to lead into a direct loss of life or directly threaten national security. It was later also confirmed in the case of Conway and Rimmer that suggests that the courts will determine whether or not the certificate of public interest immunity used by the minister in the executive is just or just a facade or shield against their unlawful actions. According to the Journal of Matrix Churchill and Public Interest Immunity, where his statement to the House of Commons on 1992 summarized that the fact that when a certain sensitive issue is brought up, the minister will have the right to issue the certificate of public interest immunity to the people. When this certificate is properly issued, it can be challenged by the people through courts. The courts will then look at the facts of the case and find the balance between the interests in justice and public interest. Finally, the court will then will look at it as a whole before confirming the certificate or allow the disclosure of the information. Lord Bingham, in the case of Makanjuala and Metropolitan Police Commissioner, also expressly stated that public interest immunity is said to not be a trump card. It cannot be used in accordance to its own interests. It was described as an exclusive rule that can only apply to special circumstances and topics. We must look into the reason of only disclosing a certain information to the public. We must also acknowledge the fact that not all information is good to the public, as there may be drawbacks to the disclosure of sensitive information. Though it is possible to indicate that if all information is disclosed, we will be able to inspect and scrutinize the power of authority in aspects of their action, whether or not they are acting ultra vires or intra vires. The question to whether the disclosure of sensitive information is necessary and would be very difficult to determine. There is no clear area of black and white, right or wrong. The grey area in between should or should not disclose must exist simultaneously. All in all, it will be only seems fit if there is a balance between these two, and so that it will be compromising for everyone.
Along the years, however, several experts and social outcry has raised concerns to series of controversial usage of public interest immunity. Stanley Alexander said that it is the undesirable confusion into which public interest immunity in criminal trial has sunk. One major concern is a result of an increasingly use of public interest immunity in criminal cases where police departments will apply for public interest immunity in order to withhold evidence such as police misconduct, which would be detrimental to police officers. In R against Gurney, 1998, the defendant was sentenced to 14 years in prison because he was found to be in possession of drugs, firearms, and money. However, he claimed that he was set up by a policeman, and on trial, the prosecution refused to disclose the information of the police officer's previous misconduct on grounds of a class claim immunity, which may be injurious to the public interest.
What is?
Mr. Gurney, you're under arrest
me,
for possessing drugs, firearms, and money illegally.
I just came home! Stop me! You're going to jail, man!
Another controversial case which caused pecuniary embarrassment to the government is Reginar Al-Swadi and others against the Secretary of State for Defense. Here, the defendants had supplied false claims for a public interest immunity certificate, asserting that it was based on national security to withhold certain documents from the claimants. The government was ordered to pay £1 million as compensation to the claimant and $2 million as fine for contempt of court. Although it is a ministerial responsibility to claim public interest immunity, it is not their duty to decide whether evidence should be disclosed in legal proceedings, even though there are adverse consequences to the information disclosed where ministers are responsible. Another major concern of non-disclosure of information is the violation of the right to a fair trial. Most notably, Article 6.3b of the Human Rights Act 1998 provides that an accused should have necessary time and facilities for his defense. Thus, by ordering a public interest immunity to non-disclosure to all relevant evidence, the court is depriving the defendant the chance to prove his innocence. In Edwards and Lewis against the United Kingdom in 2003, where in both cases the prosecution had obtained public interest immunity to withhold documents from the defendant, and the judge had also refused requests to exclude certain evidence during the trial. The ECHR held that the Article 6 had been violated and the trial had failed to deliver fairness and equity. Nonetheless, it is up to the discretion of the court to determine disclosure and will intervene to protect public interest. In Ex parte Wiley and Ex parte Sunderland in both 1993, both applicants to judicial review have been made to give witness statements at the police station without the undertaking from the chief constable that it will not be used in any civil proceedings. Lord Denning in this instance held and overruled the case of Nielsen and Lorne, 1981, that public interest prohibited the disclosure in civil proceedings that was created for the purpose of the investigation of a complaint under the police complaints procedure. Finally, the governmental abuse of public interest immunity was exposed and was highly criticized in the case of Matrix Churchill in 1981. Here, 4 ministers signed public interest immunity certificates concerning the sales of arms to Saddam Hussein of Iraq during the Gulf War. This political scandal developed into a judicial inquiry led by Lord Justice Richard Scott, who published the Scott Report, which entails the failures and abuse of the governmental powers in regards to constitutional doctrines such as separation of power and public interest immunity. Lord Scott discovered that although some of the documents were sensitive materials, many of them were internal communications between the ministers and its civil servants, not public interest substance. He went on condemning the government for using PII in order to protect the secrecy of the case. In regards to reforming public interest immunity, Sir Richard Scott scrutinized the view that a minister has a legal duty to claim public interest immunity in order to protect documents from disclosure was based on a fundamental misconception of principles of public interest immunity law. He suggested that Lord Bingham's statement in Makan Huala was wrongly perceived and that the duty to claim public interest immunity only arises when a minister is of the opinion that disclosure of documents would be damaging to the public interest. Lastly, the Scott Report regards class claims for public interest immunity in criminal cases and that it should be removed. And if claims based on the contents of particular documents cannot be justified, public interest immunity should not be claimed simply because the documents come within a particular category or class. Therefore, it can be concluded that public interest immunity can be further improved to prevent injustice.
In conclusion, it can be seen that throughout the time, public interest immunity has evolved from a crown privilege to a mechanism that allows government to discharge the duty of disclosing certain evidence in court. This has given public bodies and government the certain discretion to retain information which may be against their own interests. The Scott Report has intended to discharge such injustice, citing ministerial responsibility, failures, and also the abuse of state power. Despite several discussions in Parliament, there was no significant conclusion made. Thus, looking back the case of Conway and Rimmer, the court has the final decision of disclosing information relating to the case. Therefore, the court should have to adhere the doctrine of separation of power, as they would need to act fairly as to which type of information are suitable to be disclosed. If a document is deemed to be sensitive on grounds such as national securities and defences, it would be reasonable for the court to grant a public interest immunity. Thus, with enough consideration and balance from the court, it can be concluded that the public interest immunity would not be a tool for the public bodies to abuse their rights, because the court would only grant it when it's fit to do so. So here comes the end of the amazing world of administrative law. So we'll see you next time. Goodbye.